Hi, I'm Attorney Tom Lamb in North Carolina. In this Asbestos News Minute, I want to tell you about a April 2010 appellate court ruling which upheld a $30.3 million verdict in favor of the family of a man who died from mesothelioma. It's the largest mesothelioma trial verdict in that state's history. The case was Buttitta versus Allied Signal. It was brought by Susan Buttitta, whose husband Mark, at age 50, died from his mesothelioma a year after it being diagnosed. At the time he contracted or was diagnosed, he was an advertising executive, but earlier in his life, on two different instances, he was exposed to asbestos. And this is an unusual case because the case involved an instance of exposure directly to asbestos when Mark worked with and around asbestos products himself, and indirect or secondhand exposure to asbestos when he was a child and his father brought the asbestos dust home on his clothes after working at a GM warehouse with asbestos brake pads and other products that had asbestos. Focusing on that secondhand exposure to begin with, the contention is the father came home with dust on his clothes. Young Mark, as a child, runs up and greets his father. The dust comes off the clothes. Mark inhales the dust many years ago, and the disease process starts. Later in life, when Mark was a college student, he worked at a different GM warehouse that also had auto parts containing asbestos dust. He did this as a summer job in college. The appeal, in large part, was factual and focused on causation. The defendants contested the idea that he had sufficient exposure to asbestos, both directly and indirectly, in terms of duration and the amount of fibers that he was exposed to in order to contract his disease, mesothelioma. The trial court judge correctly saw through that red herring argument and said, yes, the New Jersey test of frequency, regularity, and proximity would be appropriate to raise in an asbestosis case where a worker would have to have had daily exposure 5 days or more for the most part of his workday in order to get enough asbestos fibers in his lungs to begin the scarring process, which is known as fibrosis, the pulmonary fibrosis, which when it's caused by asbestos is called asbestosis. Mesothelioma, however, which is a terribly fatal cancer, painful, it's just terrible, and it's caused only by asbestos. This is a far different disease process. It does not take the extent in terms of duration and fiber burden to develop in a man such as the asbestosis would. So the trial court judge saw through that, and so did the appellate court. They said, no, if it were asbestosis, we would agree with you, but it's not. It's mesothelioma, and it's a completely different disease process. The underlying trial was back in February of 2008. A Bergen County jury heard the evidence, and they awarded $8 million in pain and suffering with regard to the late Mark Buttitta, what he went through with his mesothelioma, $2 million to Susan, his widow, for loss of consortium, $9,200,000 plus for lost wages for Mark's continuing work life. Remember, he was only age 50 at death. $2 million plus for loss of services to Susan and the family, and $3 million to each of Mark Buttitta's 3 adult children for loss of parental care. It's a large award, but the jury heard the evidence. They thought it was the right thing. The trial court judge thought so as well, and now thankfully an appellate court has agreed and has dismissed the appeals by the defendants. For more information, visit asbestoslegalwatch.com. Thank you and have a good day.